These cops showed up to this man's house because their department's mechanic called that Caleb assaulted him. They knocked and Caleb's father answered the door.
Go down the driveway, please.
Shut your mouth. Go get it.
You go down to the driveway,
No.
please. Get me.
What'd you say?
He said you can go down to the driveway.
Did he say anything about a gun?
No, he didn't say anything about a gun.
Caleb, I need to talk to you down
I'm not
here.
coming out there. You can talk to me right here.
Caleb, I need to talk to you.
You can
away
talk
from
to me.
him.
That's my parents. You can talk to me right
Come
here.
talk to me down here.
No, you cannot come in my house.
I will come in there. You're going to be arrested. If you don't come talk to me and tell me your side of the story, you're getting arrested. You understand me?
You know why these officers are so aggressive and all ready to arrest him? Because there is a reason for all that.
I'll tell you what we'll end up doing, we'll get his side of the story, but what it sounds like based off your statement, we'll probably end up charging him with maybe writing him a summons to the court for assault. Okay, he can get arrested tonight too on that. Caleb,
I don't have clothes on to come outside. I'm going to stand right here inside
you
my
are
home.
getting outside.
You can't make me go out
Yes,
there.
I can, or I'm going to arrest you.
For what?
For assault.
I didn't assault anybody. I didn't even hit the dude.
Walk out here now, or I'm getting you.
Can I go get a shirt on first?
Go get a shirt on.
After Caleb walked out of the house, one of the officers tried to shut the door on his father.
You aren't allowed in here.
Thank you. I don't want my door closed.
I don't want my door closed. Hey, dude.
They immediately arrested his father and charged him with assaulting the officer, but prosecutor dropped charges. Later on, his father filed a lawsuit and settled it immediately for $60,000.
Welcome back, everybody. As many of you guys know, I'm a law enforcement trainer instructor. I train and instruct military and law enforcement all over the country on various law enforcement disciplines to include constitutional law, case law, patrol tactics, use of force, advanced investigations, etc. And here we're going to do a video response to this officer, in my opinion, based upon the case law, and we'll get into it, unlawfully arresting somebody without a warrant. Now, it appears this officer is investigating an assault that occurred, and that's 100% great. That's what law enforcement officers are supposed to be doing. They're supposed to be investigating, and they're supposed to be determining if there's probable cause for crimes. And so what I think is it always blows my mind is that for all intents and purposes, let's say this gentleman did assault somebody, and let's say the officer did have probable cause. The fact that the officer's laziness would result in a lawsuit against that officer and a lawsuit against that administration, which was going to result in the taxpayers having to fit the bill, is absolutely disgraceful. It's embarrassing. Again, these things that we keep seeing happening within law enforcement is absolutely embarrassing, because let's say there was, and let's just assume for a second that there was probable cause to believe that he committed a crime. That doesn't mean the officer can go rip somebody out of their house or from their curtilage and arrest them. And we'll talk about what I think the officer should have done and what I train and instruct. So, very quickly here, let's understand the stop and ID case law. Supreme Court has affirmed that law enforcement needs reasonable articulable suspicion in order to detain and compel somebody to identify themselves. Again, Brown v. Texas, 1979. We are all aware of that. Next up, we have the right of a man to retreat into his own home and there be free of unreasonable governmental intrusion is the very core of the Fourth Amendment. The area immediately surrounding and associated with the home, the curtilage, is part of the home itself for Fourth Amendment purposes. The front porch is the classic exemplar of an area which the activity of home life extends. As we can see, he was arrested from his porch. Now, I personally think, even if this guy was guilty, he probably should have just stayed in his house. Probably should have just stayed in his home, but he decided to come out, which is what they wanted. They just wanted the ability for him, and in their mind, what I think, again, this comes to these officers being poorly educated. They thought that as long as they could reach him from through the door, then therefore it would be a justifiable arrest. Again, case law does not state that. And again, these officers, it's very clear that they don't know case law. They don't know it, and if they did know it, they just willfully ignored it. And so, again, I get this a lot too when I'm teaching people. They say, "Well, my sergeant, my FTO, my chief, my captain, my lieutenant said," and usually how I start my courses is, I don't care what your FTO says. I don't care what your sergeant says. I don't care what your friend says, what your chief says. With all due respect to the police, to the chief of police, I don't care. Your opinion is beneath case law. It's beneath me. Your opinion on something is beneath me. It's either Is it justifiable by case law or is it not? When we're talking about the adjudication of crimes, right? Just because your chief says, yeah, if you have probable cause, go into that house and get them, it doesn't work that way, right? So again, the opinions of a law enforcement official, again, in my opinion, means nothing to me. I did not take an oath of affirmation to the police chief. I took an oath of affirmation to the Constitution of the United States of America. Next we have here, you can see v. Wisconsin, 1984. The United States Supreme Court affirmed that a warrantless home arrest without exigent circumstances violates the Fourth Amendment protections against unlawful search and seizure. Again, Welsh versus Wisconsin. Again, the case law could not be more clear. So what should they have done? Well, as you can see here on your screen, arrests and warrants and domiciles. Payton versus New York, 1980, gives us everything we need to know. Here it says it's unconstitutional under the Fourth Amendment of the Constitution to search a home during arrest where there is no arrest warrant and where there is no exigent circumstances. The Supreme Court holds that the entrance of a person's home is a critical point where constitutional safeguards are heightened, which is too substantial an invasion to allow without a warrant. The Supreme Court has held for Fourth Amendment purposes an arrest warrant found on probable cause implicitly carries with it limited authority to enter a dwelling in which a suspect lives and where there is reason to believe the suspect is within. Again, Payton versus New York, 1980. So again, everybody has their own can have their own opinions on it. I'll just tell you what I train and what I teach. If you are conducting an investigation, right, no matter what happens, regardless of how you decide to do this arrest, you're going to have to arrest, and then you're going to have to submit a report, right? Your report's going to have to be completed before you go to adjudication anyway, right? So the core principle is once that arrest is made, that report has to be submitted fairly quickly. And at a minimum, in order to hold him in the jail, you're going to need to have a probable cause affidavit for his arrest. So, given that you already have to have a report or a PC affidavit completed, upon holding him in detainment, in custody, in jail, why risk anything? Me personally, again, everybody's different. The assault has already occurred. The damage is already done. If you know he's at the house, perfect. Again, this is 2025. I get warrants done electronically all the time. So, cool. Well, we know he's here. I plan to make the arrest. Okay, I have no problem sitting on it. Personally, my report's already going to be completed. If it's just me, I just, when I go to somebody's house, I'm not there to mess around. I'm going to you're going to come out or we're going to kick in the door and we're going to use a reasonable amount of force necessary to effect the arrest for the warrant that I have that has a wet signature from a judge. That's just me, though. I mean business, right? When it's time to arrest people, it's time to arrest people. We're not talking. I don't care about your opinion. I have the warrant. I have all the case law. I have the report. We're going, right? I don't like to sit there and have to. I don't do back and forth. Back and forths are beneath me, and I know that may sound harsh for some people, but I'm not going to sit here and have a back and forth with somebody. I either have the lawful authority to do my job or I don't. So for me, if I already have to conduct, the paperwork's already going to have to be complete, irrespective. Very, very soon after arrest, it's going to need to be able to be presented. So why waste around with it? Do the investigation. If you have probable cause for an arrest, cool. Get that report submitted. Everybody's different. I mean, in a pinch, you can literally copy and paste it. Boom, let's go. Right? So again, you have to have the report complete anyway. Why not get a signature on it? Again, it's too easy, especially if you're already in this situation. Again, I just don't know why you wouldn't. Again, that's just my personal opinion. I don't know why you wouldn't already have that done. So what I teach, and again, everybody could have their own policies and procedures. If you have probable cause, write it down, complete your report, complete your PC affidavit. It's all the same thing. It's all based upon the same information. Get it signed by a judge, then go to the house. Order him out. He doesn't want to. Boom, you're kicking in the door and you're getting him. You have the warrant. So, again, everybody's going to look at this. Everybody's going to look at this differently. But at the end of the day, the most important thing as law enforcement that we need to do is we need to respect constitutional rights. We've taken an oath to constitutional rights. We have to respect constitutional rights. We have to protect people. And the way we do that is understanding the jurisprudence as it relates to case law and understanding where your authority is and what you can and can't do. If you have probable cause, cool. Get an affidavit, get it signed. You own the house. You own him, you own the house. Get it knocked out. So that's just my opinion. Now, when it comes to this, like I said, we've talked about this because people keep asking me, well, how do we hold law enforcement accountable? Well, again, this is not real, but imagine if you had a law that was a criminal statute for law enforcement that willfully broke the Constitution, right? That willfully decided they were going to make an unlawful detention or arrest, right? Law enforcement saying they're not doing it. Police administrators are saying they're not doing it. Pro-police people are saying they're not doing it. So if law enforcement is saying that they're not violating people's rights, if police administrators are saying that they're not violating people's rights, if pro-active police activists are saying that they're not violating people's rights, there should be no problem with this. You can put this in and immediately with qualified immunity, and qualified immunity would have, because as we know from Pearson versus Callahan, as you can see on the screen here, qualified immunity does not protect government officials from violating statutes and constitutional rights. So again, make a statute that's based upon the Constitution that no person may be convicted of unlawful detain, arrest unless the state has proved beyond a reasonable doubt each element of the crime. The elements are any peace officer, state of Oklahoma, boom, 21, okay, statute 99, whatever state statute you live in, insert there, copy and paste, real simple. 2, willfully. 3, detain or arrest. 4, lawfully without authority. 5, any member of the public. Municipalities could literally enact this law tomorrow if they wanted. Because as you can see from all the encounters that we're seeing, right, law enforcement are willfully unlawfully detaining and arresting people of the public. Cool. Make it a law. You want to save time. You want to save time is of the essence. If you think that this is a massive issue that is in law enforcement, make it a state law. Make it a municipal law. Get the law out there. Boom. You can have immediate accountability, immediate transparency like that. Again, I hope that was helpful for you guys. If you guys have any questions, please leave them in the comment section below. I'm curious. What do you guys think? What do you guys think of the case law? What do you think of creating a law and jury instruction that directly targets law enforcement, that violates people's rights? Curious to know what you think in the comment section below. As always, guys, long live the Republic.